Okay, for us to start the meeting, I'm going to end the voting now. And share the results. So it seems that majority of the attendees today are from the journalism and writing, editing, proofreading, fact-checking expertise, some marketing, and some not a freelancer. And well, we have some hirers here today as well. And on a scale of 1 to 5, how familiar are you with IP issues relating to your freelance work? Well, 40% says that you're familiar, and most are quite unfamiliar with the IP issues. So that's good. Dr. Stanley Lai, you have a good audience here with you today. And let me start by welcoming everyone
absolutely.
to
I can see that.
Okay, welcome everyone to today's session. As a start, let me just run you through this webinar system. All attendees will be on listen mode automatically. So if you need to speak, maybe ask a question later on, we'll rather you type the question on the Q&A mode. On the right-hand side of the screen, at the bottom, there is a chat pod. The chat pod is for you to make comments, give any links that you want to share. And the Q&A mode, which is the next tab on the right, is for you to type in your questions, which we will use for the Q&A session later on after Dr. Stanley Lai's presentation. So the polls, as you had participated just now, will be on your screen. You just need to click your choice answer. So what we're going to do is besides just now that set of polls, we are having 2 more polls in between the presentation, and to give an idea of what kind of knowledge the audience like yourself have about various aspects of the topic being discussed today. Okay, just the background about Singapore Press Club. Some of you are new to us. Singapore Press Club is a purposeful networking organization that was formed since 1971. So we are already 49 years old. Next year, we are celebrating our 50th anniversary. It serves a vibrant media community in Singapore across all platforms and all media-related professionals. We are dedicated to provide professional development for our members, and we strive to provide thought leadership on issues of the day. So this freelancer workshop basically is to help our members with knowledge sharing as well as acquisition. Now, so what is the Singapore Press Club Freelancer Network? The reason why we are providing this topic is we started this freelancer network on early June, and this is a free service that we offer for our club members who are able to offer freelance project work. So the aim is to provide an efficient platform to connect companies and individuals who need freelance media related services. The network is open to all categories of members with a good track record in media related work. Many of our members have very good experience working in Singapore Press Holdings as editors, journalists, and also many companies and individuals in the marketing, branding, and also MediaCorp for video production and TV production are also our members. So we have a whole suite of services that we can offer from our member community. So this is how you can join the Freelancer Network. We have a FAQ, which you can go to the Press Club website to view, or you can check out this link, which I can type out on the chat board for you if you would like to reference it later. And if you want to join the network, you need to complete the freelancer profile form. This is a Google form which allows you to indicate what sort of experience you have to offer, so that we can include it in our network for companies intending to hire freelancers. If you are not a member yet, you can join the Press Club. So we have a Press Club membership link here. I'll put it on the chat pod as well later, so that you can go in and check out all our memberships, all the events that we organize, and also sign up if you're interested to join us. Without further ado, let me introduce Dr. Stanley Lai. He is a senior counsel and partner at Allen Gledhill. Stanley is a partner of the Litigation and Dispute Resolution Department. He also heads the firm's intellectual property practice. Stanley specializes in all forms of IP litigation and information technology disputes, and is also a commercial and chancery litigator. He has appeared in arbitrations both as arbitrator and counsel. He maintains a very strong advisory practice for IP data management and cybersecurity, serving a broad spectrum of clients, representing clients in investigations that are undertaken by the various agencies. In biomedical and pharmaceutical sectors, Stanley has substantial experience in advising on healthcare and medical IP as well, and regulatory issues concerning medicine, generics, patent linkage, biosimilars, medical devices, clinical trials, product recalls, and product liability. Stanley is currently the chairman of the Intellectual Property Office of Singapore. So he's the most experienced person in this area. He is also a member of the Singapore International Arbitration Centre, IP panel, and Singapore Copyright Tribunal. So he also serves as a principal mediator of the Singapore Mediation Centre and published extensively on IP and information technology law, including the book entitled The Copyright Protection of Computer Software in the United Kingdom. So with no further ado, let me just run you through with the 3 topics that Stanley will run through before I hand the webinar over to Stanley. Okay, Stanley, over to you.
Thank you. Thank you very much, Janet. And appreciate that slightly long and extensive introduction. I appreciate that. Even though I know, yeah, it is. I should have shortened it. It's good to actually meet all of you. I say meet in quotation marks because I can't see any of you. I can barely see Janet. I'm very pleased to meet you today, basically to talk about freelance work and some of the IP issues that arise. And thankful that you filled out a poll, because I needed to get a sense of where the mainstay is as far as your professional life is, and most of it is journalism and writing and so on. So I think that's good. I'm also heartened by the fact that most of you rate a 3 for IP awareness. So that makes my talk simpler, and also I think promises a more engaging Q&A session, which I hope to participate in with you. But let me just go through some questions first, and then some issues, and then when we get to the point of another segment, before I go into the second issue, which is social media concerns, we'll run another poll with you, and then also another one before contracts, so that we totally maximize the engagement experience, and more importantly, we're trying to maximize the relevance of this talk to your day-to-day work, and I appreciate that. So let's make a start in terms of bare-bone introductions to IP. And you'll see that where IP rights are concerned, we're really talking about legal rights that are expressed over the creation of the mind and the fruits of your creation and writing. And to that end, you see very much the conversation of intellectual property merging into intangible assets as well. And you speak of it almost like a genus or a new form of asset class unto itself, which is also capable of transactions, commercialization, assignment, and licensing. And this is something that we do as part of our daily work. As far as the IP rights that can be engaged by you know, freelance work, and most commonly, because freelance work in journalism especially, as well as writing, typically would be in the field of copyright law that covers a range of literary, dramatic, musical, and artistic works, and then there are neighboring rights as well, which we'll go to in a minute. And principally, it's copyright. So when you do writing, it's always in a form of a literary work. The question then is, what must you do to attract copyright protection, and what rights do you have as the author as to ownership? So pretty much this is what we'll do. As far as copyright is concerned, we talk about the language of subsistence. And I mentioned that with subsistence, you have a reference to literary, dramatic, musical, and artistic works, which is the what we call authorial works. I mean, typically, everything starts from words on a page, or musical notation on the page, or drawing, painting, sculpture, or even when you do musical works, as the composition. These are things which go to defining the gamut of authorial works. And then in our Copyright Act, we have a reference to other subject matter, which will be what happens after you create authorial works. There will always be a need. A writer always needs a publisher. Well, at least let's talk about traditional mainstay relationships between author and publisher. An author will always need a publisher, or work for a publisher, or work for some other person that creates a medium for widespread dissemination. So with these rights, you also see another genus of associated, what we call other subject matter, mostly in a form of sound recordings, films, TV broadcasts, cable programs, and published editions. So for example, if you publish a work into a novel, your original manuscript is always your literary work, and that would attract 70 years plus the author's life. Most of us, I think if we are younger authors, then there is potentially a longer runway for exploitation, because after you live a full life, let's say until 100, and then maybe that's maybe my personal aspiration. I think realistically 80, and then over and above 80, your estate will then be able to enforce copyright and collect royalties for another 70 years over and above your life. So that's actually the strongest copyright to have, the author's copyright. If you were to license a publisher to publish a work, the publisher's copyright is actually rights in the published edition, which is actually just 25 years from the calendar year of publication. So you can already see that even though you're relying on a publisher to take your work to market, to the extent that the publisher did not contribute to the writing process, the publisher will actually enjoy a smaller, a shorter term of copyright protection compared to you, the author. Which is why when you're dealing with publishers, most of them would want you to try and assign your author's copyright to them. For this reason, because when you assign your copyright to them, they potentially have 70 years plus author's life in terms of the exploitation period. So a lot of freelance writers encounter this problem when they first start, because when they first start, everybody is more anxious to get the work to market, which means you need the publisher more than the publisher needs you. But because the publisher needs you, but the publisher will try and entice you to assign your copyright to the publisher, whereupon the publisher will actually literally create your entire work. And he will basically control the work going forward, which would extend also to subsequent publications over and above 25 years. Because of the inherent rights, you can also translate, authorize, and permit different translations of your work into other languages. And that's all within the gamut of the rights that are controlled. So it starts always with the baseline first copyright. That's a very important point to bear in mind. There is a de minimis principle that exists in copyrights. So when you're dealing with slogans and and phrases, some people say, look, you should be able to claim copyright protection. It's still subject to qualitative assessment. Is it original, first of all? And is it of sufficient length? For a word itself, it's difficult to claim copyright assertion or to claim copyright protection over a word by itself. It's very important to understand the difference between ownership and authorship, because the author of a work is the first owner, presumptively by law. So where we see a displacement of this arrangement, if the author, for example, works in the course of employment for an employer, a company, then arguably that person, even though he's the author, the first ownership rule is displaced in favor of the employer, depending on whether the copyright work is created in the course of employment. The one exception from this is people who provide a contract for service, as opposed to a contract for of service. And typically, independent contractors, freelance writers, would typically fall under the first category, where you're providing a contract for service, which means you're treated more like an independent contractor, in which case you would still, the baseline rule would still be that you actually own the copyright because you're the author of the work. And that's an important principle. Sometimes you are commissioned to create a certain piece of work or writing for an organization. Then usually, typically, is a commissioning arrangement. And just bear in mind that within the Copyright Act, the rules of commissioning are actually quite narrow and pertain to things like paintings, sculptures, photography. For writers, the best move is always to say, look, let's have a contract of commissioning, and be careful that you don't give away your copyright unless there is economic justification to do so. Because the consequence of the person wanting to benefit from a commissioning agreement is usually the commissioner. The person actually wants you to create something, would want you to sign an agreement whereby everything that you've created, the copyright of that, would be owned by the commissioning party. If there is no agreement, then the baseline rule must still be that the first ownership of the copyright must be to you, the author of the work. So if you wonder why entities would always want you to execute commissioning agreements, is to try and displace the provisions in Section 30 of the Copyright Act. With copyright and with the categories of right to which copyright subsists, like literary works, which are like a form of subject matter, together with artistic works, dramatic works, and so on, there are this list of exclusive rights which are attached to the copyright in that relevant work. So whoever owns the copyright can exercise and do any of these things. By the same token, they can also license any of these things. And as a further extension, they can also assign any of these individual rights. You may not want to assign all the rights, but maybe reserve some unto yourself. So when it comes to publishing the work, for example, that's typically a right that would be of great interest to publishers. Because for a publisher to be able to own its own copyright in the typographical edition, it also needs a license from the author to publish the work. Hence, the point I made earlier about publishers always trying to get assignments of copyright to them, because then they don't have to ask you for permission. They can just operate on the basis that they own the baseline underlying copyright, and from there they can actually publish and exploit the published works at will. And that's an important point to bear in mind. You also see artistic works having their own set of exclusive rights attaching to this subject matter, and similarly for other types of works. Whatever you deal with, each type of work or subject matter other than work in the Copyright Act has its own respective exclusive rights. And it's always better and important from from the point of view of analysis to see where you're operating from. So similarly for published editions, you are making, by a means that includes a photographic process, a reproduction of the edition. So when you talk about printing presses and printing multiple copies, it is actually the exercise of this right. So typically what happens with a copyright infringement proceeding is when someone does any of the exclusive rights that I just listed in the previous two slides without your authorization as the copyright owner. And that's why you take licensing seriously, because a licensing is effectively a permission to a party to undertake certain acts which would fall within the scope of your copyright ownership in relation to the work in question. And that's something to always bear in mind. It lies at the very heart of a licensing arrangement. A licensing arrangement basically absolves the licensee from any infringement proceedings because permission will have been given. Now, do you need a license in every instance of copyright usage, and exploitation? The answer is not really, because typically a bare permission or consent by the corporate owner is sufficient to respond to infringement. What freelance journalists and writers would also be mindful of is the extent to which they can make use of other existing works on a fair dealing basis, which is clearly an exception in the Copyright Act. And these are found in Section 35, 36, 37 of the Copyright Act. Section 35 is the overarching fair dealing defense, which also extends to, that covers, also specifies certain factors that have to be taken into account when the court decides whether by taking another work, you are deemed to have satisfied the fair dealing criterion. And you'll see these factors are clearly ones that are skewed to commercialization and commercial purpose. If you're clearly using a substantial part of another person's work and reproducing it or communicating it to the public for the purposes of commercial exploitation, then you may find that the fair dealing defense moves further away from you in terms of application. Whereas if you're doing it more for an education or a teaching purpose or something that is more that is not laced with any commercial objective, you may find that the courts are more disposed to making a dealing of fair, making a finding of fair dealing in your favor. And I would say that for journalists, I think it's Section 36 that makes the biggest difference. And Section 36 actually allows you to recreate and reproduce works for the purposes of criticism or review. And this is typically the provision that is most sought after, because you'll be making these comments, and as long as you give sufficient acknowledgement to the work and the authorship of that work, then you would satisfy this criteria. And the criteria which I mentioned earlier, the fair use factors in Section 35, these factors similarly inform the application of Section 36. And in the case of journalists, Section 37 is really created for you, where you actually report current events. And even if it means reporting current events which comprise copyright works, this would give you a certain journalistic license to do so. But I thought it's useful, and you may know this already, but it's useful to see from where does the right to do so actually arise, and it's in Section 37, Section 36 of the Copyright Act. And so you see these fair dealing provisions also replicated in the sections of the Act that deal with the other types of rights or associated rights, such as sound recordings, and films, published editions as well. You will see a similar spread of these defenses. So when a defense is not available to a potential infringer, then it comes down to remedies for infringement. And typically for intellectual property and also for copyright, most owners prefer to get injunctive remedies. And the Act also facilitates the grant of damages, which are generally thought as compensatory to cover the rights owner's losses, and they are specified. And you can also get statutory damages. very much imposed on Singapore by reason of the US-Singapore Free Trade Agreement, which was entered into more than 10 years ago. And that in itself provides a framework so that our laws do not depart and are not that different from those of the US. So perhaps at this juncture, before we launch into social media, I can ask Janet to launch the next poll, if you don't mind, Janet.
Sorry, give me a second.
Thank you.
Okay, the second question is up. Okay, can the rest of people please key in your answers? If not, I'm going to close the voting now. Okay, 5, 4, 3, 2, 1, vote close. Okay. All right, I will share the results again. Okay, and we'll close the vote and go back to presentation.
Thank you. Yes, thanks very much. And it's good to know that the role that social media plays in our respective lives. And I can imagine for the gig economy and also for freelancers, how much it is important to use social media in the course of your work, both as a repository for content and also as a potential platform and disseminator of content. And so I think the first thing to bear in mind is when dealing with social media and IP, it's very important to again break down the basics of what I tried to convey in the first part of this talk into the relevance in terms of what you're producing. Number one. And number two, how is the ownership of copyright situation addressed in that situation? In other words, to what extent can the social media platforms, or SMP for short, make use of your work to the extent of repositioning, reposting, further dissemination without having to obtain permission from you every time? Because don't forget, what we said was the first basic principle is that the author of a copyright work is the first owner. That remains the baseline rule. And we also said in the earlier session that this general rule of authorship and ownership can be displaced in a contract of employment situation, or in a commissioning agreement, which actually mandates that you, the author, are being commissioned for a certain purpose, and the agreement goes further to say that any ownership of copyright shall vest in the commissioning party. So similarly for social media and copyright, evaluate your position. And the first thing to say is that when you look at the terms and conditions of the social media websites, and we've just reproduced some sections of this, so that you get a clear sense of what exactly the terms are like. You will find that there's an extremely broad retrospective license that's created in favor of the SMP by you every time you post something. So that's a very important principle to bear in mind, that you can't object to the usage that is made of your material by the SMP, because you've already given an implicit license. And the way you've done this is just by sheer participation in the endeavor. And through that participation, you've laid yourself to a certain extent vulnerable to the prospect of a very wide, cross-border, wide, perpetual, royalty-free kind of license. You find that these terms exist for most social media platforms, including Twitter, LinkedIn. You see the similar language, and that is the extent to which any user-generated content must bear in mind that you may come up against these issues, even though you've got the right. It's not gone to a stage where Facebook is basically saying that whatever you create and post onto my platform, I, Facebook, own the copyright. That's not what they're saying. But they're saying the one thing that is just short of that, which is you may own, but I can use indefinitely on any terms of my choosing, because you've given me the permission. And the acceptance by you of these terms is by your signing into the account and your act of posting. So by conduct, you have basically agreed, and therefore an enforceable contract exists between us. And if you look at all the terms and conditions, there are also provisions where they can actually do things and make some decisions over what you post, or even to exclude it if they consider certain grounds met. So that's where SMPs play. And whilst I realize that a lot of us will use this and see this as an opportunity to increase our mind share, increase our influence. The downside is that they also acquire certain permissions from you, and that is generally the price of admission, if you like. So be aware of the terms and conditions. They are very broad, and it also extends to photographs, which are a form of artistic work. Photographers that do this on a freelance basis, for example, always have to be very mindful that every time you put up a photograph that you've taken, and which you have taken with pride, the value of the same photograph is to a certain extent be constantly diminished once you upload it into a public site for all to see. So you will find that the world's renowned professional photographers very, very slow and very careful to upload their works and put their works out, because what they're very mindful of is the fact that once it goes up and is published through an SMP or any other public source on the internet, it goes viral, and the value of that, or the perceived value of the photograph, has completely been negated, and also to the point of disappearance by reason of the dissemination. It is also possible to see a lot of adaptations being made in relation to posts. And the question is whether you can actually repost and retweet. And the answer is yes, because that's also part of the social contract, if you like, in making use of social media. But I think when you want to quote, first of all, it has to be accurate. If you want to quote large tracts of an original work that's created by another party, then bear in mind what I said earlier about Section 36, 37 of the Copyright Act, which you invariably will have to fall back on, because you want to basically say, well, this is sufficient acknowledgement of something that should be considered a fair dealing for criticism or review, or for the reporting of current events, which is most relevant to journalists, and that's the one point to make. And you carry these disciplines and principles into the social media context as well. And just bear that in mind in accordance with the permissions that you've already given. Sometimes people try to take shortcuts and reproduce material that may be found on another website or another social media post or something that can be seen from a social media profile, and you want to reproduce certain things. And sometimes you try and say that there's a material alteration or embellishment, so that with everything that you've done to the work, you should actually be the corporate owner, because it's gone beyond being an adaptation. And you would see from the Property Guru decision, which is one example, that it is a case-by-case determination on whether there's an adaptation, number one. And more importantly, the court sees whether there's actually any discernible difference between the different elements of the work. And through that, you understand that when you make an adaptation argument, you really have to show a change of subject matter. It cannot be that you're making very insignificant, insubstantial changes to the original copyright work, and then trying to justify that as being an adaptation for which you should actually deserve separate and independent copyright protection. The law approaches intellectual property infringements and copyright with a certain cynicism, if you like, to what they consider to be wholesale or substantial reproductions. It's all the judge is always asking himself or herself: is the defendant's actions in reproducing this work in this way still undergirded by the need to somehow misappropriate or usurp the labor that was put in by the copyright owner in creating the work? So whenever I take a case to court, or I'm responding to an infringement claim, my sense and where I like the clients to be put in a position is whether the courts will think less of them for what they've done. And if the answer is yes, then the efforts must be thrown into convincing the court that there was a justification, B, you've created a significant work unto yourself for which you should be given full credit, and C, there's minimum impact to the market of the corporate owner. And these are all factors that implicitly not just address the case of infringement, but also help with the defense. I mean, you use a corporate defense in Section 35 to 37 if the other side has already succeeded in corporate infringement. That's the whole idea of using in invoking a defense, because what you want to try and do is to meet the case to say, notwithstanding a corporate infringement, there is an actionable exception to corporate infringement that I can call on, namely the defense of fair dealing. So that's something that we want to deal with. So, all right, we've made some progress. We've come to the third section, which is contracts, and I think there's another poll. So I'll turn it over again to Janet.
The poll is up. Hi everyone. While we are waiting for the rest of the attendees to finish the voting, can you kindly start keying in your questions into the Q&A mode or chat bot? I've also actually put into the chat bot the links to the Freelancer network for you to refer to. Thank you for your patience as we have quite a number of people attending today's meeting. We'll have to wait for a few more minutes. Oh no, a few more, less than a minute hopefully, for majority of the attendees to finish voting. Okay, I shall count down 5, 4, 3, 2, 1 to end the voting. And this is the results of the vote. So majority of people key 1.
So that's interesting. Thank you, Janet. And I'll just resume. It's interesting because what I do see is that contracts come into our lives quite a fair bit as freelancers. And I suppose the starting point would be to ask yourself this question: are you in a how strong is your negotiating position in relation to the company hiring a freelance writer or your counterparty? And I think where we want to try and get to for the Singapore Press Club as well as the freelance network is whether you actually can come together and find yourself in a position where you can develop template agreements that can allow you to negotiate your rights more productively with a company that sometimes they may just be very anxious to get the project done, so that's your value add, and so they need you to do certain things, and at the same time you also want to make sure that, look, am I giving too much of the furniture away? Am I running the risk, for example, of giving up my copyright? And what's the downside to that? Does it preclude me from doing future work for another company, particularly one in complete direct competition with the first party that's engaged me? So I think it's useful for us to just think about, what will I do with this piece of writing? Is it just a one-off, never to be reproduced? Is it so pertinent to this company that I should assign my copyright? But will in doing that, will I hinder myself in future engagements with other parties, including those who are in direct competition with the first company? You see, as a freelancer, unlike an employee, or what we call in the business, someone that is in a contract of service with a company, owes certain duties, including the duties of loyalty or fidelity. So you can't really, whilst being an employee, you can't really be writing and having creating IP for another entity, for example. And that entity doesn't necessarily have to be in competition with you, but because anything that detracts from your service to the company can be considered a breach of the employment agreement. So if you want to actually assign the copyright in a way which you no longer own it, then the question is, make sure there's certain things that still apply. Like, are there sufficient attribution rights so that whatever is done, whatever use is made of your work going forward by the company that's hired you to do the freelance work, insist on attribution. Certain copyright acts in the world actually have a positive paternal right of attribution. So until the day you die, and even beyond that, for the duration of the copyright, you have the right to demand to be attributed and recognized as the author of the work. It's what we call a paternity right in copyright. In Singapore, you don't see the paternity right in the legislation. What you do see is the prohibition of a false attribution of authorship. So you cannot falsely, whilst you don't have a positive duty to assert that you are the author, there is a recourse for you if someone misattributes authorship of a certain work and directs it to another person, whereas it should be you. Then you can actually enforce that right. But to put all that beyond question, insert attribution rights in the agreement so that whatever is done with the work that you've done, any future publication, make sure there's adequate acknowledgement, because I think that's also important for freelance writers. Your biggest your portfolio of work, if I may say, would really be the selling point and the nugget of your offering. So having that is important. And also, I think in this social media engaged world, the number of the further use that's made or citation that's made of your work, for example, would also carry additional value and currency. So it starts with attribution, because if you don't insist on attribution, then no one will even bother to mention you, and then that's where the work is always what you don't want is 25 years, and I encountered that in the course of my work as well. 25 years ago, a certain piece of writing was done. There's no record of attribution, so you're really stuck when you're trying to find out who the author is. And if you can't find an author, then you have to treat it as an orphaned work, which is a terrible way to describe a literary work. But it can be. Orphan works are works for which you can't actually identify the provenance or the originating author. So attribution, and then also the extent to which you can still maybe get a license if you want to use it for your own purposes or to create an additional work. So it really depends on what the project is, and I'll be happy to answer any specific questions. But just as a general principle, you want to be quite clear about the structuring of agreements to protect rights, and even as freelancers, because I think the next 5 to 10 years would see a growth, I think, of freelancers, not just in the writing sphere, but in other areas like ICT, computer programming. It's already happening. Increasingly, you will find that there are more and more authors, but what you don't want is to see an exploitation of the authors with the rights unevenly recognized in agreements. Because don't forget, intellectual property at the very macro level is always a subject of balance of rights between the rights owners and the users. So in cultivating the different economic relationships that arise, especially between authors and publishers, and authors and commissioning companies and so on, you would also want to see a certain plethora or remnant of permissible acts which the author can still enjoy, recognizing that he in fact was the creator. A lot of many important considerations in a written contract have to be considered. Don't sell yourself short when it comes to the number of hours put into the creation of the work. If there's going to be an adaptation element, in the sense that the client may say, look, you write the core material and I will add to it, or from what you've prepared, we may make modifications over time. Make sure that a license is given, not because you want to be a stickler for operating within the four corners of the Copyright Act, but you also want to, what I always consider, the optics are as important as the substance, in the sense that you're also sending a right message to the companies you're dealing with, is that you observe copyright law assiduously, and you would want to make sure that that discipline is also followed by the party that you're dealing with. That actually sets a very useful basis to proceed, and in many cases may actually mitigate the unequal bargaining position that you may initially perceive before you undertake the engagement. So by asking these questions, that's important. Payment, don't sell yourself short with consideration as well, because if at the end of the day, the party commissioning you as a freelance writer is going to be owning the copyright in the work, well, obviously that comes as a premium, because by owning the work, you're also suffering a setback in a restriction in not being able to deal in that work in a way which you would otherwise deal with if you you remain as the author and the copyright owner of the work. So that is something which is market driven, and I agree that it's market forces that will determine the outcome. And sometimes when you don't reach an agreement, or you have an agreement and then after there's a dispute that arises, photographers are very vulnerable to this. Photographers that agree that I will deliver 250 photographs to the commissioning party has to create 750 photographs to pick his 250. So then the question is, what happens to the remaining 500 photographs which never see the light of day? And then later on, if the subject matter of the photograph, for example, is to say convicted for social, for breaching social distancing rules and control measures, and then suddenly you're in a possession of a photograph that you can make use of, he then kicks up a fuss to say that you should not be using that photograph because we had a contract. The photographer will then say, no, we didn't. We only had a contract for 250 photographs, which you own the copyright for pursuant to our engagement. But in creating the 250, I had to cut out 500, and my copyright ownership of the 500 is still intact. So that kind of dispute is very messy. And if it comes to court, it certainly it will open a hornet's nest. But what you want to do is to say, look, instead of court proceedings, is there some other way? Can we opt for dispute resolution? Means that take us to a point where we can negotiate a settlement in front of a mediator, rather than to make use of a full-blown court proceeding, which would mean time and cost. And for freelancers, time is precious. Every minute that you're spent or distracted in defending or prosecuting a litigation in court is precious time that could be put to much more creative use. So think about mediation as a possibility, because mediation is an informal procedure, lower cost, not so expensive, but depending on the mediator, may actually yield a good outcome. And a good mediator will facilitate a settlement which ultimately brokers a compromise. Not that each side would win 100% of what they seeks to do, but to the extent that common ground can be found, it will be. And to the extent that misery may be shared in terms of the adverse outcomes, it is shared by both parties. So there's no sense that one party has actually come up stronger, but it does bring a certain finality to the future of the relationship, where at least it's settled and things don't have to escalate. So that's useful. Litigation is by contrast a much more open process, much more expensive. Although we did mention a development that forthcoming wise, you may see changes to our court rules that will allow small businesses and individual creators to actually prosecute their own claims and try and commence civil proceedings at a lower cost framework within a fast track procedure that the courts may introduce. And that will hopefully introduce to freelancers another vehicle for swift adjudication. It's not going to be as expensive as a full-blown high court trial, but at least you will get some assurance from the fact that you can calculate a financial exposure, and also at the same time hopefully derive a satisfactory remedy. So that's litigation. So with that, I'm very pleased to end the presentation, but I'm happy to deal with questions and answers next. So is that how we should do it, Janet? How much time do we have? First of all, let's do a time check.
least 15 to 30 minutes if everybody is agreeable. There's quite a number of questions. I will try and post them now.
Do you want me to go through them, or are you going to flash them into the screen?
I'll try and flash them onto the screen.
Okay, if you can do that, then I can focus on answering the question, then to manipulate the size of the Q&A, which I must say is challenging to my eyes. I should have brought my bifocals along.
Okay, here.
Yes. Yes, thank you. Yes. Yes, you're right. But every time you click agree without reading, as a matter of law, it's difficult to argue that you didn't read, and even you really didn't read. By clicking, you are deemed to have accepted. So that's the problem with SMPs, and of course, nobody will read the terms and conditions. That's the reality, and they know that. So when you participate and use social media, there is a ready acceptance of the terms, which you then cannot easily resolve from. I mean, based on what the ones that I showed you, that the what we reproduced for your reference, it will show that you own the basic rights still. It's just that you've given a very large, broad license to the SMP in question to make use of your work. So the extent to which they can, they're restricted by law on a territorial basis. So, for example, the SMPs here will have to respect the law on online falsehoods. They have to respect the laws on defamation, sedition, and all the other devices used in our system to control the social media discourse. But at the same time, you would find that pretty much they have carte blanche to do a lot, to actually manipulate your content, make use of it, maybe aggregate it in some other way or some other posting. You may not even recognize it after you see it, but you've given an explicit license to them on a worldwide perpetual royalty-free basis for them to do pretty much many things to the work. But that's the price of admission, as I always say. If the copyright depends on whether the copyright was transacted with the publisher. If the publisher manages to get the author to assign the copyright to the publisher, then if the publisher goes into liquidation, the liquidator or the judicial manager and so on will then administer the copyright like any other asset in an insolvency context. If the copyright is still vested in the author and all the publisher has is a license to publish from the author, and then the publisher only has a 25-year right to undertake publication, that may be a situation where the liquidator in that situation will just be administering the publication, the publishing right until such time where there's a complete winding up of the publishing company. Then the obligations would end. Many clauses that deal with an assignment or a license of copyright to publishers would usually have an insolvency clause, so that the minute there is a insolvency or even a stage where you may doubt the financial ability of the publisher to continue business, that may be a terminating event for the license. So the author may be able to say, look, on the basis that you're going into judicial management or an insolvency process, I have grounds to terminate the license, and that's probably the time to do it, and for the author to really look for the next publisher. Because don't forget, publishers are important because they provide the typographical arrangements. They bring together the art and the marketing of your work. So the reputation of the author cannot be divorced from the stature of his or her publisher. So if the publisher is facing difficult times and may actually run into insolvency, the author would want to extricate himself or herself from continued obligations, and that's why the contract should be ring fenced to cater to insolvency, and then you can look for another publisher after a certain print run is over, and so on. That some care has to be taken over that process. When you ghostwrite for someone, it is the case that a ghostwriter is still an author in his own right. The law doesn't distinguish between authors that are ghosts or authors that are not ghosts and are live, red-blooded personalities. The only question is, what is your arrangement with the person for the entity for whom you are ghostwriting? You may ghostwrite for someone and then you basically acknowledge that someone is then the author or the stated author. But that is actually that would actually require an agreement typically, because you are basically foregoing your rights of authorship. But I think if you are the other party, you would want to make sure that the ghostwriter would always lend assistance where necessary to facilitate any copyright claim. Because you see, if a person is actually not a true author, then that is also a basis for challenge when it comes to enforcement of copyright. So if you want to hire a ghostwriter, typically it will usually be with things like commercial literature, where you just want someone to write for you, but not insist on credentials and insist on acknowledgement or attribution as author. But if you're writing something more creative and that actually you're trying to create a novel, but you don't want to be stated as the author, just bear in mind that it's a vulnerable position to take, because the law will still treat the author as the first owner of copyright, which means that the ghostwriter may actually own all the rights, and you may end up with nothing. And a similar arrangement for joint authors, where you may, if you don't have an agreement, it always becomes a dispute as to who did more of the work in terms of creating it. Can your respective contributions be ascertained? Because that is also a definition that has a bearing on the legal status of joint authorship. It's very important to settle authorship, because that is, from that, everything else derives, you see, like ownership rules. You assess and you prove originality by showing that the author wrote it himself and did not copy any material from a third-party source. The only person that can answer questions on that is the original author. So in that case, when you want to transact with a ghostwriter, the ghostwriter needs to agree to give any assistance in litigation. And of course, in any open dispute, the one thing that will come out is the fact that you ghostwrited for the work, which will not do the existing or the stated author any favors, because first of all, it's not his copyright to enforce, or even if it was his copyright, the party that ultimately proves the subsistence of the work has to be the person that wrote it. So that's a special consideration. If the third-party company basically either pays for sponsored content or for public, custom publication, typically it's just a straightforward transaction between the third party and the author. The publisher is not something that comes in unless the author wants to publish the work and publicize his efforts or his literary prowess through publication in the form of a monograph or some other relationship. So the author-publisher relationship is more author. It starts with the author and the author trying to exploit his creations in the market. If the author is then hired by a third party to create certain content, that is what happens with a lot of freelance writing, where you're basically tasked to write 2,000 words, for example, extolling the virtues of a certain product, which will then go into the marketing literature, for example, then it's not really a publishing arrangement. It's more just a straightforward engagement contract or a commissioning agreement by the company for your services. How wary should we be of copyright trolls coming after commercial entities that use images from free stock image repositories, such as Unsplash? Well, start with looking at Unsplash and other stock photo websites. Just make sure that the terms and conditions clearly show that copyright is waived, or that it's genuinely public domain material that can be used, reproduced, and communicated without reference or without permission to the person that took the photograph. Copyright trolls are a very strange term. They are basically entities that may try and assert themselves as owning certain IP rights, with a view to saying that, look, whatever you've been doing, it's still subject to my copyright. And what is the troll's objective is to secure some sort of licensing arrangement. Trolls may threaten litigation, but ultimately what they try to do is to bring you into a licensing arrangement. Because once you license, it puts actually the licensee in a terribly weak position, because you can't then, it's not easy for you to threaten or challenge validity of a work if you actually voluntarily agreed to license it. Because through that, there must be some tacit acknowledgement which will be put to you that you somehow acknowledge that there is a right to license in the first place, which is why it then looks slightly disingenuous for you to later on then say, well, actually, there wasn't any right to begin with. Then the question is, then why do you take the license? So copyright trolls don't necessarily come after commercial entities unless it is the original owner of the copyright of the photograph in question, and they see that that's been done. And that's a situation where you need to get your lawyers involved, and ultimately it requires strict proof of actual copyright authorship and ownership. And in this world nowadays, especially with photographs, it's also not straightforward, because in the days where you had Kodak and, rest in peace, where you dealt with negatives, and it was easy to manage photographic copyright. Now with digital photography and multi-formats, you can have RAW format, JPEG, GIFs. You have so many different formats now for photographs. The difficulty is this. The authorship of a photograph, the author is actually a term not really only defined in one context in the Copyright Act, which is in the context of photographs. And the definition unhelpfully says that the author of a photograph is the person that took the photograph, takes the picture. So you appreciate that, that may have worked as a definition many years ago. But now the reality is everybody's got a camera. Every owner of a device or mobile phone or other portable device invariably may have a camera attached. So does it mean to say that if I borrow your camera, your phone, for example, and then I took a photograph and then returned the phone to you, if you want to follow the strict auspices of the Copyright Act, you are still the author of the photograph using a phone that's installed in a camera that's installed in a phone that doesn't belong to you, even though your image is actually stored permanently or until erasure in the mobile phone in question. So you see the difficulty now in trying to establish the ownership of photographic copyright, and so a great deal of uncertainty now has entered this sphere. So when you talk about trolls, the trolls themselves better be very clear on the provenance or the derivation of the photograph in question, because if I can find another source for the photograph, or another public source, or even a private source, that may cast doubt on the troll's assertion of copyright. So I'll be working along those lines as well. when advising any party to respond to trolls. And if I was acting for trolls, well, then the first thing I wouldn't call them is trolls. I mean, very often in the patent world, for example, you may have read that there are patent trolls, and these are mythical creatures in the form of companies that go around looking and seeing whether their patents are in use or exploited by any party. And nobody troubles you if you're not successful. But the minute you hit the headlines, when there's a threat of, when there's the possibility of heavy investment, or even an IPO, even better still, more embarrassment, they'll introduce themselves to you at your weakest. And then the question is whether you want to be seen to be embroiled in a lawsuit, or whether you actually want to bring it to a closure, and that's where a license agreement solves your problem, and to the troll it brings great success, because what the troll would have satisfied its own KPI, which is to bring you to the point of litigation where you then end up signing a license, and then he doesn't have to go on to prove his case. In copyright, trolls are less prevalent, but if you are advising a copyright owner, because a troll list ultimately has to be a copyright owner, because only copyright owners and or their exclusive licensees can sue independently. You will need to also go through the process of creation and make sure there's no doubt whatsoever as to the authorship. It starts with that one person that took the photograph. And if it's not clear how that was derived, then it is going to, you'll be very slow to advise a copyright assertion in that case, because it may end up with you not being able to prove copyright subsistence. One of the points that I should have also mentioned in the presentation is the law actually contains a number of presumptions. If the defendant does not challenge authorship or ownership of copyright, then there's almost a presumption that is invoked at law that would say that, look, because it was not challenged, is deemed to have been vested in the party asserting the right. So if you're a freelancer or you're being troubled with trolling activity, it's very important to put everything to strict proof, because the failure to do so may result in the presumption being invoked against you. And it will make the case for proof so much the easier, because you then have to rebut the proof of corporate ownership, rather than to have put the burden on them to prove strictly that copyright vests in them. It's a big difference in litigation. It depends on your contract with the web company. The terms and conditions are important. If the web company takes a leaf out of Facebook's terms and conditions, then you may have a problem. So you will want to make sure that even though there may be standard terms and conditions for the web company, you either agree to your terms where you retain corporate ownership, and you prevent the web company from making use of your content or articles, because whether it's a paid personal website or not, it doesn't matter, because the question is whether you're allowing the web company to make use of your proprietary work. You see, so just be wary, and that's where I think as freelancers, one constant problem is when you're always facing template agreements by the parties that are hiring you. Now, without even looking at a contract, one of the first questions a lawyer advising a freelance writer would ask is, how did these terms and conditions come about? And they say, it's a standard form given to me by the other company. Now, you may not think much of it, but to the lawyer, the red flags are already there, because nobody will give you a template where the terms don't favor that party that offering the template to you. So that's the basis that I would encourage us also to scrutinize agreements, in the sense that if you want to reach a more equitable, balanced relationship with the party, then it starts with the point that no party is going to give you a contract if they didn't have their rights fully protected, and some you would obviously need to push back and assume that that's the basis working forward. Oh yeah, I know the editor very well, and we're great friends. We went to school together and all that. Yes, but your contracts with the company, you see, and you want to make sure that I mean, if they're on the company standard terms of business, you can be quite sure that the provisions would favor the company and protect it adequately against you. Video contributions to a web publisher website. TikTok is the latest. I mean, if you have children, this appears to be the latest scourge. And I would have preferred it if they didn't exist. But unfortunately, they do. I hope nobody from TikTok is here. TikTok actually, the question then is, who owns the copyright to a video that's uploaded on TikTok? And TikTok is also to be treated as a social media type of site, except that you're not dealing with the medium of words. It's more these very short, time limited videos. And the original copyright owner is arguably the person that filmed the video. TikTok obviously has social media platform type license rights to do of it what they will. If someone actually shares that video to a website, if it depends on whether the video or more relevant, the copyright in that film, which is that TikTok segment, who controls the copyright of that, and that will be the person that is entitled to enforce rights in relation to that video. So don't confuse that with TikTok's a platform, but it still comes down to who is the owner of the TikTok video. So the use of that content will be subject to potentially to an assertion. If you're the chief illustrator, it depends on the contract of employment. Because if you're an employee and you're doing other things for a company, like accounts or HR, can you imagine if you create a piece of art or an artwork in your spare time, and then the company says, actually, you know what, you did it while you're an employee, therefore we own the copyright to your artwork. And so what was your core business? Oh yeah, I was actually doing HR. That is the quintessential example of how Section 30, subsection 6 has to be applied in the Copyright Act. What that basically says is, so does it fall within the scope of your contract of employment? The contract of employment is what defines the scope of what the company would own in terms of an employee's creations. So depending on the contract, if it's wide-ranging enough so that notwithstanding your work responsibilities which are defined, anything that you create between the hours between dawn and dusk, or even after that on a 24-hour basis while you remain in the employ of the company, regardless of relevancy to your assigned scope of work at that given time, it's owned by the company, then you may have a problem and they may control the copyright after you leave the company. However, if the contract is silent, then I think a case can be made that whatever you did was on your own time and it falls outside the scope of your employment in any event because you're doing accounts. But it is a case-by-case basis, which is why you have to scrutinize your employment contract. Employment contracts come in several forms. You have the most detailed form, which hopefully will deal with intellectual property rights. Or you may have a letter of engagement, which makes reference to another set of terms in another employee handbook that's owned by the company, which you would be well advised to see before you sign anything. So terms can be can be incorporated by reference to a contract of employment without the employee maybe not even seeing it. And if you haven't seen it and you still sign, once you've signed and it's your signature, the principle of contract law that we apply in Singapore is such that it's difficult to then argue that you cannot be taken to have agreed. As long as you have signed and it's not a forgery, or that undue influence has been applied to lead you to sign, then chances are you are then at the mercy of the terms of the contract including any other extraneous document that may have been referred to for the purposes of incorporation of terms. And that's generally a good rule of thumb to go by. Splicing and syncing in content from other third-party YouTube videos is a very common practice. The only question is whether it can be a fair dealing, or whether the taking of the splicing or the syncing is done on an insubstantial basis. And just be mindful that insubstantial, when considering whether that substantial taking of another person's work is not a quantitative test. Copyright law applies a qualitative test, which means that it may be just 5 seconds from another music video, but it may be 5 seconds of the most important part of the song or music video that is what gives that particular music video popularity. So the court may take the view that the first 3 lines of the chorus, for example, of a popular hit, even though it's 3 lines out of possibly 10, it is still a substantial reproduction. It is not a quantitative test. So bear that in mind, and you have to make a value judgment. And sometimes if you do face a 50-50 decision where you're not entirely sure whether it's sufficient, your lawyer may not be entirely sure, then sometimes it's worth just seeing whether, let's try and see whether we can get a permission to do that. Because the downside of not getting permission is to expect a reaction from the copyright owner may cause you more problems downstream than if you were to take the short-term approach, endure some short-term pain, but at least get some finality for downstream usage, which may hold you in better stead than going downstream and then becoming popular. Nobody troubles you if you're not popular. If you're popular, then one of the consequences of fame is people will try to knock you out in terms of copyright, and you see that happening all the time with people that try and claim rights to actually very successful content in modern media. Any feature published in a newspaper, usually the online terms and conditions for that newspaper, I mean, certainly like SPH, for example, they have very strict rules on the republication or any display of any proprietary content taken from the newspaper. So we're very, very careful always to advise clients to respect the terms and conditions of the newspaper proprietor, because I think over the last 10 years you've seen that newspapers have become much more sensitive to republication and any sort of use or display of any proprietary article within the publication. So the answer is probably no. See the terms and look at the extent to which you can reproduce. There's not much of a leeway, especially for commercial purposes. So just be mindful of that.
Okay, that's the last question that's being posed.
Okay.
Thank you, Stanley, for
yes, thank you.
Very detailed answers to all the questions. And thank you, everyone, for being here with us today. We thank all of you for staying put for this 1 over hour, but I think you have a very good session takeaway from Stanley. And we hope everyone have a good day. Thank you, everyone. Thank you, Stanley.
Thank you very much, Janet, and thank you to everyone for participating. And I look forward to continuing my links with the Press Club and also with the Freelancing Network. May it go from strength to strength. Thank you.